Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And today, we've got some stuff to do. We've got things and stuff and happenings and goings on to discuss, to engage in, to discover, to endeavor to understand, to reach beyond our to achieve some lofty ephemeral goal. I'm not naked. I clearly have a salmon colored shirt on, just blends in with my pasty skin. And yes, this is my honorary FU Nimation shirt, Dragon Ball Z, that I will wear because hoes mad. Now, if you don't know what I mean by hoes mad, you may have noticed that I, of course, am just absolutely I don't want to say catapulted, cannon shot, ballistade right off of Twitter. Like I am gone. By all accounts, it appears I'm gone. Who knows? You know, always watching for the possibility of return, but the hope is waning. So now the actual hoes be actually mad at someone else because they don't have me, right? They don't have me. So now Dominique Sky. I don't know if you guys have heard of Dominique Sky. You may have seen her implants, or you may have seen her bad dental work, or there's any number of things you may have seen. Depending on how much you pay, you may have seen a whole lot. But Dominique Sky is really going after Amish. I don't know if you have seen how hard this chick is going after Amish. I know they're going after Tug. They are on full frontal assault. And we didn't even have to pay for the premium method for that. But yeah, so the Thoughtocon in chief, as I am calling her right now, is really gunning for Amish. They're like attacking him personally and all this stuff. And you know what that means, right? You know what that means. It's only a matter of time before he's accused of several hate crimes. Maybe turns out Amish was the third man on the grassy knoll at UConn. That's what I heard from Dominique Sky. He was the one endorsing the N-words, the rampant N-word usage. But yeah, so they, I mean, look at them. Look at how this works. This is how the system works. Again, fellas in the anime industry, if you don't understand yet how it works, you're on the list, the broken staircase list. I know we've all forgotten about that because it was like 6 months ago and they've been really busy destroying Vic. So that broken staircase, that's gone. It's probably not, they didn't mean that. I'm safe, right? No. Here's how it works. They destroy the one that's in the crosshairs first. And then when they can't do anything else to that person, they move on to the next one and the next one and the next one. And it doesn't stop. It doesn't stop. It's not going to stop with Vic. By the way, hey, fellas in the anime industry, you all owe Vic like 8 months of time that he bought you with this. Get your shit together, guys, because it's about to get pushed in by a bunch of angry hoes with strap-ons, because they're coming for everybody. And if you don't believe me, just ask Cuba Gooding Jr. how it's going. Just ask, because it's coming. Every single person, they already had that test case. What was his name? Robbie something? I don't know who this guy is. You guys probably do. By all accounts, seemingly a nice, kind of normal guy. They had a test run on that guy. Test run on that guy, but it's coming for the next one. Just wait. Just wait. I can't wait till it gets to the top, right? That'll be fun when it gets to the actual predators. Or do you think they'll push it off until they're out of the industry? Robbie Damond. Yeah. That's who they went after. Raymond? Damond? I don't know what his name is. He's Tuxedo Mask from Sailor Moon. Yeah, they went after that guy. So anyway. It's coming. Omar coming. Except this time, Omar's teeth are prosthetic horse dentures. And and for $20, you can see Omar's naughty bits. But coming for you. I'm off Twitter. They're coming for you. That's fine. C'est la vie. So I assume we'll have, of course, some non-usual, some hate watchers of the show. Hello to you. Thank you for watching. You're boring. There you go. If you weren't, you could do this and people would watch, but you are, so they don't. Sorry. All right, now that we got that out of the way, what are we covering today? We got some Proud Boys. Some Proud Boys. 2 Proud Boys have been sentenced for the brawl up in New York. We're going to talk just a little bit about the Proud Boys up in New York who got sentenced. Remember that the Gavin McInnes, he backed away so that would somehow reduce these guys' sentences, right? Like that's how that works. Gavin McInnes, who was absolutely not charged or implicated in any sort of crime, by him stepping away from the Proud Boys, he was doing them a favor, though. Like, that's what he was doing there. He started an organization. He got a bunch of guys riled up. He claimed himself as their leader. He organized them. He taught them how to not masturbate. He taught them about cereal. He got all the important things. He got them into a fist fight. And then for their protection, he distanced himself from them. So remember that. Also, he's got a documentary coming out about how hard it's been on him to have that happen. So you can check that out too. Not that I'm throwing shade at Gavin, but I might be throwing a little shade at Gavin. Either way, Gavin is out there not taking responsibility for the organization. But these guys are. Now, they may be guilty of a crime, right? They clearly are. They were convicted. They're being sentenced. Never mind that Antifa refused to cooperate with the victims of the by identifying the victims of the Proud Boys, and that New York has said that, we definitely would have prosecuted Antifa, but we just can't locate those guys at all. They're just not helping us any. So I guess we just have these guys. So we're going to prosecute them. But they definitely would have gone after him. So we're going to talk about that in just a little bit. We're going to talk about James. Just a tiny bit. I don't know a lot about James other than what happened today. Which is not good stuff. And some maybe encouraging words from Governor Abbott on the James issue. So we're going to talk about Proud Boys. We're going to talk about James, and then we're going to talk about these Lemoine notices of intent. Lemoine notices of intent. This is his big brain, big disease-riddled brain play here to not actually do what he says he wants to do, but still get a result from not doing what he says he wants to do. So there you go. We're going to read through those. We'll talk about them. I don't know if they're the biggest mystery on earth, but they're interesting, I guess. We got to speculate on a lot of it because, you know, there's like rules or are there rules? There are rules. There are rules against pretty much all of it. So I guess we have to talk about that too. I have a little bit of cherry Coke left. I have a little bit of these bubbles left. No, I have this is like a full can. Oh, I bought a new whiskey. It's called America. I bought America whiskey. It's a bourbon. It was not expensive. So I assume, but it wasn't. Listen, it's aged a minimum of 6 months. Like at least the 6 months it goes in a barrel, okay? So for just at least the 6 months. It might be 6 months and 10 minutes. It might be 6 months and 12 hours. It just depends how long it takes them to get the barrel out, tap it, and to put it into bottles. I don't know how much it, you know, how long it actually sat there. But at least the 6 months, though. One thing that was that I was reminded of is part of my Patreon promise was that once I got to a certain level of Patreon, I would have a whiskey review and drunk stream at least once a month. And I've been derelict in my duties. So I went on a quest today to find a new whiskey, new to me whiskey. That's the America whiskey. And then tomorrow will be a whiskey review. And then the rest of the stream, whatever we cover, will be covered. And I will drink more than normal, if that makes sense. I'll drink to intoxication or something, so we can get some honesty up in this piece. So I invite you to get something, drink with me, but I'll review the whiskey as honestly and competently as I know how. It's probably not going to be a great review, but it'll be a great time. And then we'll go through some stuff and we'll talk about some things. Oh, also, just a brief shout out. Maybe we'll talk about this tomorrow a bit too. Jessica Yaniv is now, or Jonathan. I don't know which one it is. The large Hildebeest is is officially, I think, a racist now, according to Canada. So that's great. Hates the Asians. And I think doesn't get his balls waxed. Something like that. So we might try and talk about Yaniv tomorrow. I don't know. We'll see. I want to just let people know that hashtag that thing lost. And that's good. That's good. There is some justice in the world somewhere. But yeah. These people, man. These people. Okay, let me get some of these stories pulled up here. Also, well, maybe we'll do this one first. I'm going to see if I can get some info on this. I've talked to the author of this article on stream before. He's a really cool guy. And maybe I can reach out to him again. I like this guy. And I talked to him so long ago. I bet many of you have no idea who he is and would probably be surprised that he was on the channel. In fact, it was such a long time ago, he might be surprised he was on the channel. But I'd love to talk to him again. Let's see if I can get this pulled up here. Oh my gosh, I'm so competent. Is this it? Did I do it? I did. Okay. Now, the person I've talked to is not Cody Wilson. However, controversial gun rights activist returns to Ghost Gun Project after sex crime plea deal. That's right. Your boy Cody Wilson is back. Cody Wilson is back. Back with the what is it? I can't even remember what the stupid Defense Distributed. Oh my gosh. Defense Distributed in the Second Amendment Foundation. They were taken over by a woman while Cody was going through his legal issues. He's back. I would love to have Cody on stream. I don't know if Cody would come on. I don't have a reliable way to contact him. My Twitter had information on the arrest of Hillary Clinton. So it got to the back of the head. But someone I have had on the show and who might be very interesting to talk to about this and other things, and I'm already planning on reaching out to him for an overall Second Amendment panel, is the author of this article, Stephen Gutowski. Stephen Gutowski, he is the Second Amendment writer for the Washington Free Beacon. And this guy covers all of the Second Amendment stuff you could want. So if you want to find, if you want to know what's going on in the gun rights world, just type Stephen Gutowski into your, type it into your search bar, follow him on Twitter. Very smart guy, knows what's going on, knows his stuff. He's not a lawyer. He's a great journalist, though. And I mean, this guy is in on the issues. So when I say he's not a lawyer, I'm not saying that to disparage him. I'm saying this guy is not a lawyer, and he probably knows more about Second Amendment stuff than most lawyers, self-included. Self-included. This guy is in it daily. So, gun rights activist Cody Wilson told the Washington Free Beacon he will be returning to Defense Distributed, a company that manufactures machines that make gun parts, after striking a plea deal in his sex crime case. Wilson said he was invited back by Paloma Heindorf, who took over the company after Wilson was arrested in 2018 for paying an underage girl for sex. He also said that the company would be launching a new ghost gunner milling machine designed to help manufacture firearm parts on do-it-yourself and small business scale. Cody's the... I mean, this is a bounce back, right? Oh, we've destroyed you as the government because we charged you with this crime, a crime that, with the publicity combined with your other activities, make you into a pariah for life. You will never again do anything useful. Oh wait, you're back at your company. Oh, well, shoot. Shoot. Whoa. Okay, we're going to leave it like that. Okay. Yeah, so this is a huge bounce back for Cody, and part of this is made possible in part by his plea deal because it kept him out of jail. Remember, I said how good of a plea deal he got? I mean, he got a great deal. Now, he can't actually own a firearm for, I believe, 7 years of probation. However, there's nothing to say he can't work on this project. There's nothing to say he can't work for the company, that he can't be involved in the distribution of the 3D printing or CNC milling auto mills that they make. There's nothing that says he can't do that. He just can't be involved, or he just can't own the actual firearm. So he can't own a completed lower receiver, for example, until his 7 years are up. And then he'll actually be able to, assuming he remains law-abiding during his probation, because he got basically what's called a stay of adjudication, which means that his sentence and his conviction itself, assuming he follows through on probation, his conviction itself doesn't actually get implemented ever. And if he follows through on probation, his case is dismissed entirely as if he did not commit the crime. And when I say it's an amazing deal, it's because of that. That after these 7 years, and sometimes your probation can be cut short if you're shown to comply for like 4 or 5 years, he could petition to have it removed or reduced. He can maybe even do that at 2 or 3 years. He could petition to have it removed or reduced. If they grant it, then he's done. If they don't grant it, then he just keeps going, fills out his 7, and then he never commit a crime, ever. It's dismissed, done. Can't be held against him. Gun rights are fully restored. All of that stuff is good. That's a great deal. Cody's still a pretty young guy. So anyway. Okay, so let's see what else. Wilson's return put him back at the center of legal battle over homemade firearms and just how far Second Amendment protections extend. He has for years now been at the center of several lawsuits seeking to curtail the distribution of firearm blueprints online. His new brainchild will produce finished gun parts for popular firearms like the AR-15 and 1911 using basic templates and raw materials, but will work faster than previous models and manufacture steel AK-47 parts as well. It's got twice the build volume, Wilson told the Free Beacon in an interview. It supports the AK-47 now. It has a variable frequency drive. It's a totally different animal. Pre-orders for the Ghost Gunner 3 began on Wednesday. Wilson described it as the ideal iteration of the mini CNC machine. Took us 5 years to figure it all out, he said, but you know, if we had like an unlimited time and budget to design this machine, this is what this would look like. Only like 6 parts, I think, are carried over from the previous generation. It's completely rebuilt. Company hopes to begin shipping the new machines by January. Wilson and Defense Distributed have been at the center of a series of federal lawsuits since Wilson's invention of the firearm design made mostly of 3D printed material, as well as his subsequent publishing of that and other firearm designs on the internet. He's been a leader in the battle to maintain the right to share gun designs over the internet. Amid his legal controversy, Wilson was accused of paying $500 to a girl under the age of 17 for sex through a website in August of 2018. To be clear, the person represented themselves as over 18 on the website. Who knows if they did in person? Also, as I've pointed out in the previous Cody Wilson streams, one of the big hurdles that the prosecution had, and probably why a plea deal was actually possible, especially a plea deal this good, is they couldn't prove that Cody Wilson had sex with her, because they had video of her entering and leaving the hotel room. They had video of him picking her up in an SUV. They had video of all sorts of stuff like that, but they didn't have any video of the sexual intercourse. And the one witness who would know what happened would be the girl. And the girl lied already. She had to lie to establish the account on sugardaddiesmeet.com, where she represented herself as 18. So you've got someone who is a liar who's going to then try and testify that she's totes telling the truth now. And you've got a defense attorney who likely is ready to just hammer this girl on her lies, find other evidence of her lying, talk about the parental involvement and parental pressure for finding out that maybe their little girl was a prostitute. All of these things were weighing against the prosecuting attorneys in this case, and likely pushed them to a deal. So whether or not Cody had sex with this girl, whether he knew, they certainly had no information to show that he knew she was under 18. That is not a defense, or under 17, I should say. She was 16, I believe. But being under, not knowing that she is under 17 or under the legal age of consent is not a defense. That is not a defense at all. You cannot use it. However, it does raise questions about if she lied, what his intent was. All of those things go into a jury's mind, even if they're supposed to disregard his, I didn't do it, I didn't know. It's just not an affirmative defense, but it is a jury defense. What if this girl lied to your son? Right? What if this girl lied to your brother? How many other people has this girl lied to? If this didn't happen to this defendant, would this girl still be lying and getting other men in trouble for the same crime? So, who knows? That's how a defense attorney would have to approach this. It's a very uncomfortable thing to do because you have to literally take down a child. And most attorneys don't do it. I don't know if I could do that. I don't want to ever have that case myself. But that's what's weighing against the prosecution. And that's going to be playing through the mind of the jury. Anyway, I'm tangenting here. In September 2019, the judge in Wilson's case accepted a plea deal which reduced the charge to injury to a child. Under the plea deal, which is weird because he definitely did not violate that statute. As far as I can tell in Texas, it would have been impossible for him to violate that statute. But okay. Under the plea deal first published by Ars Technica, Wilson was sentenced to no prison time but must register as a sex offender, attend sex offender therapy, pay a whopping $1,200 fine, and refrain from contacting the victim, among other conditions. Victim's mother had harsh words for Wilson at the hearing where the plea deal was accepted. Oh, this will be interesting. Our daily life was shattered, but she never wavered from the truth. I mean, except when she lied and said she was 18. She said in a statement read in court, once she knew who you are and what you did, she never wavered. She remembers the gun you put in her hands and the feeling of your skin. But you ran. Despite the publicity you have always been seeking from your fans and followers, you ran. Yeah, yes. He was in Taiwan and chose to stay in Taiwan in the hopes of avoiding hopes of avoiding a felony charge and conviction. He ran. You hid in a foreign airport and only came back because you were made to. She stood up in a public forum despite talk of conspiracies and setups. Well, do they have the whole statement here? Oh man, where's that? Okay. So here we go. Oh gosh. Here we've got this thing. Here's a statement from Mom. I've never read this, so this is interesting. This is an impossible task. Somehow I am supposed to make a statement that fully explains your actions, but my truth is over a year ago. I always hold in my hand the minute you paid my daughter for what you did to her. Because it wasn't transactional, I guess. The investigation period was terrifying. Reading who you are and what you believe in created a very real and reasonable fear for our family and everyone in it. I guess who he is and what he believes in. So they thought that he was going to 3D print a gun and murder them? Was that... I don't know exactly what that means. So I would take pictures of her every time she left my car in the months leading up to the case, just in case I had to ID what she was last wearing. Our daily life was shattered, but she never wavered from the truth. Once she knew who you are and what you did, she never wavered. That sounds motivated, right? She remembers the gun you put in her hands and the feeling of your skin. But you ran despite the publicity you've always been seeking from your fans and followers. You ran, hid in a foreign airport, and only came back because you were made to. She stood up in public forum despite talk of conspiracies and setup. I pray that you will not be killed, especially that you will not be killed by a gun. The truth is you are now hiding behind the laws of the country you mocked for years. But the biggest truth is my daughter is strong, vibrant, and has a beautiful future. And I speak this truth in front of you because that's the most important truth in all of this. It's a weird statement. That's a really weird statement. But you don't get to... I mean, a victim impact statement is a victim impact statement. And you don't really... What's a prosecutor going to do? Say, don't say it? It's not going to hurt his case. Very weird, though. Notice how many times she said truth? Pretty interesting. Okay, sorry. Asked to respond to that statement, Wilson told the Free Beacon, if it had been so severe, I would have been prosecuted. Oh, snap. Wilson and his legal defense have said he did not know the girl's age when he paid her for sex. Obviously, I regret it happening, Wilson said. It was a massive distraction, but in order to feel guilty, you have to have a criminal mind. You have to know you are committing a crime. See, Cody, he is a law school dropout. I believe a second year law school dropout because he decided to pursue other projects. I don't think he graduated. But he certainly took his criminal law class. He's speaking, of course, about mens rea. Mens rea is the criminal mindset. That is the intent behind the vast majority of criminal acts. Wilson insisted that despite laws that prohibit felons and others from owning firearms and previous reports to the contrary, he would still be able to possess them. I'm definitely not a prohibited person, he says. I haven't taken a conviction. There's no felony record. Travis County doesn't treat me as having lost my voting or my firearm rights. I thought he had no firearms while he was on his probation, so I'm not sure about that. But maybe not. I don't know. Even if I wasn't allowed to own firearms, I could still run this company. That's true. I think he's not. I think he's not allowed to own firearms during his probation period, which is the 7 years. This company deals with software and components that aren't firearms. Critics have long criticized the Ghost Gunner 3D printing of gun parts and home-built firearms as ways for criminals to circumvent gun laws. Though possessing firearms remains illegal for people prohibited from owning firearms regardless of whether the guns were home-built. Asked why he felt he was the right person to lead defense distributed through its legal battles after pleading guilty to the crime, Wilson said a moral case wasn't necessary for him to participate in the cause he has long embraced, adding that he may take a less public role going forward. It just has been my cause, Wilson said. I don't know how public I need to be anymore. If it hampers the cause like I thought it would last year, I'd definitely depart. But I've been invited to return. If our people still want me to be there, I'm definitely going to be there. Wilson said Heindorf would remain in the leadership role. He would not have as absolute a leadership role as he did before leaving the company. He also said the company would use the money it makes from the new Ghost Gunner to pursue its political and legal objectives, including the ongoing suits against it. He said the company's new machine comes at a key moment since Democratic presidential candidate Beto O'Rourke has promised to send police to confiscate firearms. Beto is all about how we're going to take your AR and AK, Wilson said. Well, this is a machine that does both. You can't not like this guy's stance if you actually appreciate the idea of free speech and the Second Amendment. You can not like his acts. You can absolutely not like his criminal acts. I personally don't believe that it's a good idea to go to a website like Sugar Daddy's Meat at all. But, you know, what am I? The moral police? No. I don't think that's a good idea. I think his lawyers got him a really good deal. But I think that good deal comes, he's right. If it would have been so severe, if everything would have been so bad, there would have been a more aggressive prosecution. They have every reason in the world to prosecute this guy as hard as possible, and they didn't. Why? Their case was weak. It just was. And they were really, really worried after all of that, after him fleeing to Taiwan, after him being involved in these high-profile lawsuits, those prosecutors were worried about losing that case and ending their political careers because they were done. You don't prosecute Cody Wilson on a sex crime and you're gone. Get out. At least they got him something. Something. So, let's see. There we go. Okay. Let's get the next thing. Hold on, I gotta pull it up here. What do we got? Oh, let me read some of these chats real quick while I'm thinking about it. And then we'll move on to the Proud Boys. And then we'll hit the letters in just a minute too. Ryan Mercado says, remember Nick, Führer Lemoine is already getting a sizable kickback of the GoFundMe. Yeah, we need to probably... Lemoine needs to depose himself and admit how much money I've been paying him directly from that GoFundMe. The reason why he's filing paperwork is so that he can get the whole thing to himself. And how's everyone, including the chat? How are you guys, chat? Asks Ryan Mercado. I'm great. Fluffy Tet says, quick question. With the same people working for Funimation and Okratron, and Funimation using Okratron, Sabbath's controlled Funimation, how is that not a conflict of interest? Seems that this would be shifty business, one hand paying the other. Hashtag Yeet Sabbath. Well, I think Sony should take a good hard look at it. I would definitely not want a employee of mine also running a competing business that somehow has veto power over my own casting decisions while also subcontracting from me. Very weird relationship. But it's up to them, right? They can do that. They can have that weird relationship. Not particularly illegal. It's just odd. So, there. We are good, but still pissed. Oh my goodness. Yeah. Anthony Olson says, haven't caught a live stream in a while. Are we talking about drinking until you do things like the night with Yellow Flash? Oh no. Tomorrow night will be the drunk stream. By the way, if you haven't caught a show in a while, let me warn you, please make sure that you're actually still subscribed. YouTube is doing a fun thing. They've announced this to many creators, that our subscriber numbers may be decreasing over the next few days as they remove old or invalid accounts or something like that. So I have seen several people suggest to me that they have been removed from their subscription. Just make sure you're subscribed to the channel. If you want to be. If you don't want to be subscribed, don't be. But if you want to be subscribed, make sure you are still subscribed. If you only check in on the show once in a while, you may have been removed by YouTube. So thanks YouTube. Very helpful when they do that. But yeah, just so people are aware that that's going on. That was done before. Yeah, it happens every so often. So this time they actually announced it, which was nice. So I'm just relaying that to you. Okay, so now we've got some Streamlabs here. The Pie Baker says, hey Nick, as we have slowdown in cases, I'm going to remind you of the Fig Opera divorce. And with respect to redacting names and other identifying info, we have the prequel of Parental Murder and the sequel of Legal Manchild, both of which are parts of the saga. Ooh, that sounds interesting. China says, we Chinese, we play joke, we go pee-pee in your Coke. Nick number 34, China number 1. So thanks, China. That was nice of you to contribute to the show, I guess. Baron von Stargard, thank you for the donation. There's no question there. So there we go. And this one is really relevant to the conversation. I see it right now. So Knight of Hopek says, unpopular opinion. B-word is physically and mentally unharmed. Prove me wrong. So he's talking, I believe, about the girl in the Cody Wilson case, the victim. I don't know. I have no idea if she was physically or mentally harmed at all. What I do have an idea of is that when parents find out about something, teenagers' activities and attitudes change very quickly. So, because you might be like in a lot of trouble unless you blame it on something. And the parents in this case, and they're in a tough spot. Don't get me wrong. Like, you don't ever want to be the parent who finds out that your 16-year-old daughter is shacking up with random guys online for money. That is not where you want to be as a parent. But they did find that out, and that's tough news. So, they're trying to cope with this as well and figure out how it goes. And, to each their own. To each their own. Okay. I get rid of that. All right, so next we've got let's talk about the Proud Boys. Proud Boys sentenced. Okay, so this was yesterday. Oh, God, what do we pick? BuzzFeed News? That sounds terrible. ABC News? No, I don't want to review your terms of use. Terrible. Yeah, there. Let's see here. Great. All right. Let's go. Ha! Okay, so we've got, look at this stellar portion of photography here. I've seen this picture, and it's the picture has the guy's face on it. What? This is like a JCPenney suit ad. Yeah, the same. They cut off the heads of both of these guys. What are they saying here? 2 Proud Boys members sentenced to 4 years over New York City melee. And I've got this a little bit too. What a weird choice. 2 members of the far-right Proud Boys were sentenced Tuesday to 4 years in prison for their roles in a street fight after a speech last year at New York's Metropolitan Republican Club. Judge Mark Dwyer said the lengthy sentences should deter people from engaging in what he called political street brawls. Oh, yeah. Yeah. Let's give those lengthy sentences to one side of the street brawls and not the other. That'll definitely deter the behavior. Judges, guys, the logic of judges is phenomenal. They're always smart and always on point. But, you know, here we go. Maxwell Hare, 27, and John Kinsman, 40. This guy's 40. Were convicted in August on charges stemming from the October 2018 fight between members of the Proud Boys and the loosely organized anti-fascist group known as Antifa after a speech by Proud Boys founder Gavin McInnes. Like, look at this. So that Proud Boys, they're organized. But Antifa is a loosely organized anti-fascist group. Maybe. They were organized enough to not turn over the identities of the people involved. So they're not that loosely organized. The trial was unusual in that no victims testified because they are not cooperating with police. Instead, prosecutors relied heavily on video, including security camera footage that showed Proud Boys members starting the fight. I remember that footage, and it does show something come from the Antifa side onto the Proud Boys side. It doesn't really show. So the footage that you can see, at least that I've seen, maybe there's other footage that they acquired. The footage that I saw at the time was like, it was like a doorway camera, right? And then there's a gate with a fence, and you can see through the gate, but you can't see the fence. And the Proud Boys are coming from the right side, and Antifa are coming from the left side. Now, I saw a water bottle launch across from Antifa to the Proud Boys, and then they both kind of clash in the middle, and there's a melee of sorts. And then there's like kicking and stepping and punching and hitting. So I don't know, but there's a whole lot that happened, you know, with the parties on the other side of that fence. I did read one account that the Proud Boys charged the Antifa people. Who knows? Hare and Kinsman apologized Tuesday. Their lawyers have said they acted in self-defense when a masked protester threw a bottle. Hey, look at me. I paid attention. Members of the Proud Boys and groups that were protesting McInnes' speech were then seen kicking and punching each other in the sidewalk. I'm sorry about the whole mess. I regret the entire incident, said Kinsman, a married father of 3 from Morristown, New Jersey. Guys, like, okay. This is my personal opinion. It's not legal advice or personal advice or anything. This is my personal opinion. You've got a family at home. You got kids. The hell are you doing brawling in the street? I know Antifa started it. I know you're out there expressing your political views. You have every right to do so. But man, you got kids at home. What the hell are you doing brawling in the street? No matter the fact that it should maybe be justified as self-defense or a mutual combat or whatever, this is still New Jersey. Like, ignoring all that, what if you got stabbed? What if you got hit with a bottle and like brain damage and ended up like Lemoine? Like, what? You got kids at home. You don't need to be doing that. That one hurts me a little bit. That hurts me. I can't abide by it. You won't catch me at a demonstration. You won't catch me at a rally. I don't have time for that anymore. Right? Hare from Harrisburg, Pennsylvania said he made a mistake that night and blamed hasty decision-making for his part in the melee. They don't mean this. I mean, they do, but not in the way they're saying it. This is what you say to get your sentence reduced. You show remorse. You know, you acknowledge the fault in your actions. 10 members and associates of the Proud Boys were arrested in the days following the clash. Hare and Kinsman were the first two to go on trial. Southern Poverty Law Center, a liberal advocacy organization, has designated the all-male Proud Boys as a hate group. But they designated their own CEO as a hate group and fired him. I think both of them. The founders of the Southern Poverty Law Center were too racist for the Southern Poverty Law Center, and they've both been tossed. Proud Boys made headlines last week when the police chief in East Hampton, Connecticut, ruled that an officer's membership in the group didn't violate department policies. McInnes, Vice Media co-founder, quit the Proud Boys a month after the clash outside the Metropolitan Republican Club. In issuing the sentences Tuesday, Dwyer said the brawl reminded of violent clashes that went unchecked in Europe in the 1930s, fueling the rise of fascism. Well, we know the political disposition of this judge, don't we? This reminded me of the Nazis. Specifically reminds me of the Nazis. Such violence won't be tolerated in New York City, especially at this time in the country when people are so divided, the judge said. Oh my gosh. There was a funnier one. Maybe it was New York Times? Oh, here we go. Now we can see the full view. Oh no! What is this? I hate this. Never mind. Must not have been the New York Times. There's one that made fun. Well, it didn't make fun of it. Which one did I see? Maybe it's the one on Fox. There's a funny line in one of these articles. If I can find it in 2 seconds, I will. 4 years in prison for pummeling leftist Antifa members. The wording is funny. Let's see. Oh, this is interesting. So this is Dwyer belittling McInnes. It's a shame when some people jump up and down on a platform, Dwyer said, in apparent reference to McInnes, and their followers, their soldiers, get into trouble. He added, I'm not sure the most moral responsibility belongs to these two defendants. Let's see. This was not a schoolyard brawl, the prosecutor said. These are adults who should know better. They should do better. This guy. Yeah, sure. Sure. The fight unfolded shortly after McInnes' speech. Okay, so yeah, this is the one I read. Okay. To avoid confrontation, cops directed the Proud Boys west, then south on Park Avenue, while they shepherded their opponents in the other direction. As the Proud Boys neared East 82nd Street, they saw 6 suspected Antifa protesters clad in black headed towards them. Instead of walking away, why do they have to? The defendants and their pals sprinted more than 100 feet towards their foes, instigating the fight, Steinglass said. Steinglass is the prosecutor. This is a very biased interpretation of what happens, and we have to ask why they needed to walk away in the first place. During the violent confrontation, Kinsman and Hare repeatedly punched, kicked, and stomped on the outnumbered. This is my favorite part. The outnumbered and undersized Antifa members. The large gentlemen were punching and kicking the undersized leftist waifs. The victims in the case were never identified, and Antifa refused to cooperate with the investigation. Prosecutors said if they could have located the Antifa members, they would have also been charged. Total of 10 Proud Boys were charged in connection with the incident. 7 of them took plea deals and 1 is still awaiting trial. This guy needs to... Oh, man, he needs to argue hard. I know enough about history to know what happened in Europe in the 30s when political street brawls were allowed to go ahead, Dwyer said during the sentencing. We don't want that to happen in New York. He doesn't want Hitler to rise in New York. New York Post. I think that's where I actually read it. So Fox just stole it from New York Post. Good job, Fox. Okay. I just really want to get... I really wanted to get that outnumbered and undersized. Oh, why would they put that in the article? I think they were trying to be like sympathetic towards Antifa because it was a New York Post. It's just funny. Or wait, is the Post the right-leaning publication? Maybe it was. Maybe they were just mocking them. I don't know. God, I loved it. That was funny. Thank you to that New York Post writer for doing that one. Oh my goodness. So here's, here's the deal. Public brawling, right? Public brawling, not okay. It's against the rules. It's against the rules. They don't want you fighting in the streets of New York City, apparently. 5 points. I saw that movie. Leonardo DiCaprio. I'm getting the new documents pulled up today for the case here. Okay, so these are 2 largely identical documents that we're going to go to. But I'm going to do something annoying because I was already running late getting to my computer. I was going to... I'm going to run to the bathroom. Chair Coon will entertain for just a moment. When I get back from the bathroom, we're doing the documents. So here, I'll put them up on screen. No reason not to do that. I'll be back in just a second, guys. Okay. Okay, sorry for the delay. We have something else to bring up here. Let's got another document. I put it on screen, but this is just a hint. This is a hint. Spoiler alert. We're gonna also have a discussion. A little bit of a discussion there. But pay no attention to that. That's probably not important. I don't know why. Sorry that I accidentally put that up on screen. Yeah. There you go. Don't worry about it. Don't worry. Okay. So where do we begin? Where do we begin? A brief update on the Vic case. I believe that now that it's past midnight officially Central Time, that I believe that the notice of appeal needs to be filed in the next 24 hours. I don't know that for sure. I believe that to be the case. So I'm kind of expecting to see a notice of appeal filed, but, you know, my calculations may not be the same as Ty and company's calculations. I'm waiting with bated breath. But a brief recap. This is the case of Victor Mignogna versus Funimation Productions, Monica Rial, Ronald Toye, and Jamie Marchi. This case was filed back in April of this year, 2019. And back in April, Vic sued the four parties for defamation, tortious interference with existing contracts, tortious interference with prospective business relations, and civil conspiracy. Okay. All of the parties, well, okay. Let's get the procedural background of this case. He filed suit in April. All of the parties did submit answers to the suit. Two of the parties, Monica Rial and Ronald Toye, conducted a deposition of Vic Mignogna. That was actually, the deposition was, the other two parties, Jamie Marchi and Funimation, participated in the deposition of Vic Mignogna. And then Vic was allowed to depose Monica Rial and Ron Toye. Subsequent discovery or other discovery requests to Funimation, Jamie Marchi, were obviated by the discovery stay imposed by the filing of what's called the Texas Citizens Participation Act motion to dismiss. It was filed first by Funimation and then quickly followed by the other three parties. There was an omnibus TCPA dismissal hearing after a bunch of paperwork was exchanged that we don't need to go into here. But there was a omnibus dismissal hearing held on September 6th, in which 12 of the 15 charges were dismissed, or 12 of the 17 charges were dismissed outright at the courthouse. And then a follow-up order that came on October 4th, following a failed mediation on October 2nd, I believe. A follow-up order finalizing the dismissal of all 17 counts came on October 4th. So, with all of the counts being dismissed, that gives Vic Mignogna the option to file an appeal. If any of the counts would have survived, Vic would likely not be able to file an appeal. He would have to ask for leave of the court to file an appeal, which the court probably would not grant. They would allow the case to continue on the remaining counts, and then an appeal would be filed only after that to bring the whole thing back. Seems very judicially inefficient. That's because it is. It's because this law is a cluster heap of garbage. Now, if Vic had prevailed on any or all counts, that would afford the defendants the opportunity to do what's called an interlocutory appeal, where they would be able to appeal prior to the final judgment. If that sounds uneven, it's because it is. The plaintiff has to wait for the full disposition of the case. The defendants can appeal an unfavorable decision right away. In any case, the appeal in in a TCPA dismissal appears to be on the expedited schedule, which means that they have a 20-day window following a final ruling to file their notice of appeal. And then they go ahead and comply with the Texas Rules of Appellate Procedure in filing their briefs and getting everything going in the appeals court. But the notice of appeal needs to be filed within, I believe, 20 days of the final order, which seems to be the order on the 4th. Seems to be. However, there is a little bit of potential confusion because under the TCPA, there is the opportunity to have sanctions and, attorney's fees are awarded and so are sanctions. Under the statute, they are awarded for the prevailing defendants. So Judge Chupp dismissed all of the causes of action. However, he set the sanctions deadline, or attorney's fees and sanctions paperwork deadline, to November 4th. Okay, which brings us into this weird place where we are. And what is not clear to me, and I don't think it's really clear to anybody, including the judge, including opposing counsel, I don't think it's clear to anybody where exactly the final ruling lay. I don't know if it's upon the final ruling issuing the sanction and attorney's fees. They are part of the statute, so you can make the argument that they are within that those are the final ruling when the case is fully disposed and the ruling on the attorney's fees and sanctions is done, that is the final ruling. I think that is not the wisest course of action. It seems likely that the dismissal of all counts is the final ruling for the purposes of triggering the appeal. But I don't know. You could argue it either way. My thoughts are file it early, don't have to make the argument, because there's a Texas Rule of Appellate Procedure that allows you to file early, and if it is early, it will just treat it as if it is on time when it becomes timely. So file early, allow it to mature into timeliness. You'd still be able to appeal any sanctions or attorney's fees that are awarded later. When you actually bring your full appeal, you should be able to still appeal those as part of the same action. It's not like you would have to, like you're going to give that up. That would be a little bit silly. So that said, that's where we are. We're at this interim period where the order dismissing the cause of action has been made, waiting for a notice of appeal to be filed, and simultaneously waiting for, on November 4th, the paperwork and affidavits that are required to pursue attorney's fees and sanctions. Basically, the prevailing party gets to recommend an amount to the judge, and the judge gets to make their determination. Typically, you would do this with an affidavit, some proposed orders, or a proposed order and some affidavits is more appropriate there. And then the judge would either make the award or he would disagree with it or whatever. So that's due by November 4th. Now, what happened yesterday is that Sean Lemoine, he filed a letter to the judge asking for a hearing. Rather than making a motion and setting a hearing, he sent a letter asking the judge if they could do a hearing. And then he said he thinks they can. And then he cited a case that doesn't say that they can. But that case talks about sanctions in a way that some other cases that also talk about sanctions say that they can. Now, I don't know, and I don't think anybody is 100% clear on what the rule is supposed to be, but I have heard that there are sometimes hearings on attorney's fees in TCPAs. Whether or not this is an appropriate time, whether or not that's in Tarrant County, that I don't know. I don't have good data on it. The appeals cases that are out there don't really talk about it. And that's talked about in the letter from Lemoine as well. That there's not a lot of case law over what you do here. So here's what we think. That being said, okay, we've got these filings today. So here are the filings. Notice of intent to serve subpoena for production of documents of non-party Percy Tyrone Beard. Wow. Wow, we've got a serious person in the chat hoping murder on someone else. Good God. Pursuant to Texas Rule of Civil Procedure 205, please take notice that within 10 days from the date of this notice, defendants Monica Rial and Ronald Toye, together, defendants, intend to serve on Ty Beard a signed copy of the subpoena ducis tecum, attached hereto, requesting the production of documents and thing described in Exhibit A thereto. Notice, this subpoena will push past their date for the sanctions paperwork. Because they'd have 30 days to comply with the subpoena. And their paperwork is due on November 4th. So, that's weird. Actually, the subpoena would push past their proposed hearing date as well. Also weird. Even if they served it today, it would push past their proposed hearing date. Let's see. Let me pull up Texas Rule of Civil Procedure 205. All right, hold on. 205. Discovery from non-parties. Party may compel discovery from non-party person who is not a party subject to a party's control only by obtaining a court order or by serving a subpoena compelling an oral deposition, deposition on written questions, request for production of documents, serve with a notice of deposition on oral examination or written questions, and a request for production of documents and tangible things under this rule. Party seeking discovery. Here, I'll pull this up so I'm not just reading it. I'm just seeing if there's any timeliness mentioned in here or time requirements, restrictions. You know what I'm saying. Party seeking discovery by subpoena from a non-party must serve on all the non-parties and all parties a copy of the form of notice required under the rules governing the applicable forms of discovery. Notice of oral or written deposition must be served before or at the same time that a subpoena compelling attendance or production under the notice is served. Notice to produce documents or tangible things under Rule 205.3 must be served at least 10 days before the subpoena compelling production is served. Okay, so there's the notice requirement. So that's why we have this notice. Production of documents and tangible things without deposition. Party may compel production of documents and tangible things from a non-party by serving reasonable time before the response is due, but no later than 30 days before the end of any applicable discovery period. The notice required in Rule 205.2 and a subpoena compelling production or inspection of documents or tangible things. Contents of notice. So it's a reasonableness requirement. Reasonable. They go out to serve at a reasonable time before the response is due, but no later than 30 days before the end of any applicable discovery period. Okay. I mean, I think they've got a timeliness issue here. 176.6. See if we can get to that one real quick. 176.6. Except as provided in the subdivision, a person served with a subpoena must comply with the command stated therein unless discharged by the court. Person commanded to appear and give testimony must remain at the place. Commanded to produce documents need not appear in person at the time and place of production unless the person is also hold material or information claimed to be privileged but must comply with Rule 193.3. Non-party's production of a document authenticates the document for use against a non-party to the same extent as a party's production of a document is authenticated for use against the party under Rule 193.7. Objections, trial subpoenas. So let's see. I'm guessing it's just a reasonableness requirement. See. Subpoena, let's see. Must command the person to produce. Yeah. Person may not be required by subpoena to appear, produce documents or other things in a county that is more than 150 miles from where the person resides or is served. Person whose appearance or production at a deposition may be. So I suppose the timeliness must just be reasonable, but again, I think they've got a timeliness issue here. So they're going to issue this in 10 days. It's the 23rd. That means they'll issue it on the that'd be what, the 2nd? The 2nd, and they're supposed to, they'll issue the subpoena on the 2nd. Their response is due on the 4th, and they're going to then apparently proceed to a hearing on the 18th to the 22nd. They may be able to argue that that's unreasonable. I don't know. I was under the impression there was a 30-day notice requirement for subpoenas, but I'm never claimed to be an expert in Texas civil procedure at all. But we're going to get into the other issues with this. Okay. You are commanded to produce. So here's the exhibit. This is what they intend to serve on Percy Tyrone Beard. Commanded to produce and permit inspection and copying of the following documents or tangible things at the place, date, and time specified below. List documents or tangible things. Oh, their date and time via electronic copy to Wick Phillips on November 8th. So, good luck. Good luck. They're definitely going to argue. Well, I shouldn't say definitely. I would imagine they would consider the 6 days requirement to produce all of this stuff to be unreasonable. It's also after their filing deadline. They have to file by November 4th. The other thing they could argue is that the discovery period would end on November 4th. I don't know if that's probably not a winning argument, but they could suggest that since the judge imposed a limitation or a date upon which papers needed to be filed, which is November 4th, that is the extent of the discovery period, and they needed to file this on October 4th, which would be 30 days, then 30 days prior to the end of the discovery period. Let's see. Jason Lemoine. I signed it on October 22nd, 2019. Okay, so here's here we go. Instructions and definitions. So we'll go through this real quick. The term communications means any oral or written utterances, notation, or statement of any nature whatsoever by or to whomsoever made, including but not limited to correspondence, conversations, dialogues, discussions, interviews, consultations, agreements, and other understandings between two or more persons. The term document is used in the broadest sense and includes, but is not limited to, all originals, non-identical copies, and drafts thereof. The term document includes, but is not limited to, the following items, whether printed, recorded, or reproduced by mechanical or electronic process, or written or produced by hand. Agreements, communications, including intercompany and intra-company communications. Yeah, already they're running into real problems here. Because intra-company communications in a law firm are going to be privileged. That's just going to happen. Letters, electronic mail, instant messages, text messages, correspondence, applications of any type that exchange communications, telegrams. This is, dang it! They got him! Communicating by telegram. Cables, telexes, memoranda, records, books, summaries of records or papers. Remember these, by the way, because this is going to come into play later. Graphs, charts, maps, blueprints, diagrams, tables, indices, pictures, recordings, tapes, computer storage media, accounts, just accounts, analyses and analytical records, memoranda of telephone calls, minutes or records of meetings or conferences, reports or summaries of interviews, transcripts, reports, microfilm, microfiche, telecopies, faxes, computer printouts, ledgers, photographs, videotapes, photographs, schedules, wiring diagrams, logic diagrams, diaries, calendars, day timers. I think they've said a couple of these like 10 times. Logs, reports, or summaries of investigations. Like, again, pay attention. We're going to read a rule in a second. Okay, yeah. Reports or summaries of investigations, opinions or reports of consultants, appraisals, evaluations, reports or summaries of negotiations, brochures, bulletins, pamphlets, circulars, advertising, literature, magazine and newspaper articles, or advertisements, trade letters, press releases, contracts, notes, drafts, projections, working papers, ledgers, checks, front and back, check stubs, receipts, and other documents, papers or writings of whatever description, including but not limited to any information contained in any computer or electronic information storage and retrieval device. Woo. Woo, woo, woo. Yeah, they didn't mention stone tablets specifically. And with such an exhaustive list, I mean, I guess lithograph wasn't listed. Making scrapbooking. Scrapbooks wasn't listed. So we could probably have some communication by scrapbooks that would automatically not fall within the purview of this request. The term you or your as used herein shall mean Percy Tyrone Beard. The term litigation as used herein shall mean the action cited above. Cause number blah, Mignogna versus Funimation et al. Currently pending in the 141st District Court of Tarrant County, Texas. The term Kamehacon as used herein shall mean the annual unofficial Dragon Ball convention based out of Irving, Texas and hosted at the Irving Convention Center. The term Kamehacon 2019 as used herein shall mean the Kamehacon convention hosted at the Irving Convention Center on April 12th through 14th of 2019. The term Mignogna as used herein shall mean plaintiff Vic Mignogna. The term defendants, it's Victor. Please use his legal name. Term defendants as used herein shall mean defendants Funimation Productions LLC, Monica Rial, Ronald Toye, it's Cuck, please use legal name, and Jamie March. Jamie March. All right. So thank God it's just Jamie March, not Jamie Markey. The term Rekieta, as used herein, shall mean Nicholas Robert Rekieta, as well as his entities, including Rekieta Law LLC, and Rekieta Media LLC. Unless otherwise indicated, the use in these requests of the name or identity of any person, business organization, or other entity, including but not limited to those entities and persons identified in this definition, shall specifically include all of that entities or persons' present or former employees, officers, directors, agents, representatives, members, partners, attorneys, departments, sections, affiliates, subsidiaries, parents, and all others acting on its/their behalf. And parents means parent companies, by the way, not like their parents. The The term relating to, or any variant of relating to, means reflecting, referring to, regarding, having any relationship to, pertaining to, evidencing, or constituting, in whole or in part, the subject matter of the particular request, as well as any document which contains, records, states, reflects, interprets, identifies, confirms, contradicts, or otherwise concerns that subject in any fashion whatsoever. Pursuant to Texas Rule of Civil Procedure 196.4, for any responsive documents that are in electronic form, please produce in both hard copy with Bates stamps or PDF with Bates stamps and the native magnetic or electronic form. This guy is still on magnets. We're solid state, baby. Unless otherwise indicated, the use in these requests of the name or identity of any person, business, organization, or other entity shall specifically include all of that entity's present or former employees, officers, directors, agents, representatives, members, attorneys, departments, sections, affiliates, subsidiaries, parents, and all the persons acting on its behalf. Did I just read that? No, I did, but it's okay. The time period relevant to those requests is January 1st, 2019 through the date of production listed in this subpoena, unless otherwise stated and or obvious from the context of the request. For the purpose of interpreting and construing. Well, let me insert clever name here, says all your docs are belong to us. For the purpose of interpreting and construing the scope of these requests, you are instructed to give words their most expansive and inclusive meanings. Unless otherwise specifically limited by the language of an individual request. Accordingly, A, construe the words and as well as or in the disjunctive or conjunctive as necessary to make the request more inclusive. They're pro-diversity, guys. Construe the term including to mean including but not limited to. Construe the singular form of a word to include the plural and the plural form to include the singular. Construe a masculine noun or adjective to include the feminine. Oh my God. Or vice versa. How dare they? And construe the words all and each to mean both all and each. If in answering a request you object to any part of a request, each part of said request shall be treated separately. If an objection is made to a portion of a request, the remaining portion shall be answered. I have an idea of how an objection to this request might go, by the way. Like, I have a theory. These requests are intended to cover all documents or things that are in your possession, custody, or control. A document or thing is deemed to be in your possession, custody, or control if it is in your physical control, or it is in the physical control of any other person or entity, and you individually or otherwise own the document or thing in part, whole or in part, have a right by contract, statute, or otherwise to use, inspect, examine, or copy that document or thing on any terms, or have been able to use, inspect, examine, or copy the document or thing when you have sought to do so. Okay, here we go. Documents. So here's what they're actually asking for. I wanted to get through all of the definitions because it's going to matter a little bit. It matters a little bit. Documents includes documents and communications, including emails, texts, or any other type of communication between you and Chris Slatosh, Chuck Huber, Stan Dolan, and or Rekieta concerning the litigation, Vic Mignogna, any of the defendants, defense counsel, and or the affidavits executed by Chris Slatosh, Chuck Huber, and Stan Dolan in this litigation. Documents and communications concerning Kamehameha 2019 that reference or discuss Mignogna, defendants, Slatosh, or Rekieta. So that's the request. So the requests are, they're asking an attorney. Okay, let's be very clear. They're asking an attorney for documents and communications between the attorney and this list of people or businesses or whatever. Mithrin Emmer says, let me see. Objection privileged. Lather, rinse, repeat as needed where relevant. I think your response, Mithrin, is nicer than my suggested theory. Good to see you, buddy. Good to see you. I think your response is a little more polished and professional than my theoretical response. Let's take a look at this document here. Okay. So this is from the State Bar of Texas. And I'll pull up the rule as well. I mean, the rule isn't really I'll pull this up in a minute. The rule isn't that amazing. Oh my goodness. Oh, excuse me. Okay. So we have an initial hurdle. All right. Oh my goodness. Sorry, I'm trying to organize my windows. Okay, here we go. Attorney-client relationship. This is from the State Bar of Texas. Let's take a look. This is not a long document. This is eight pages, but look how big the text is. So we'll go through this real quick. A client's relationship with a lawyer is unique. Lawyers and clients must be able to communicate freely for clients to receive the help they need, and the attorney-client privilege and the work product doctrine make this possible. The attorney-client privilege protects confidential information learned by an attorney during client representation. The work product doctrine protects the thoughts and materials prepared and communications made when lawyers and clients think litigation is possible. This pamphlet explains the basics of both protections and seeks to teach clients how to avoid common pitfalls. Attorney-client privilege. So this is the first part of the privilege here. Attorney-client privilege is found in Texas Rule of Evidence 503, and its application in federal courts is governed by the Federal Rule of Evidence 501. The purpose of the attorney-client privilege is to encourage free discussion between a lawyer and client. If lawyers and clients cannot talk to each other, the lawyer will not be fully informed, and the client cannot get the full benefit of the legal system. Oh, excuse me. The privilege also helps clients feel comfortable seeking early legal assistance. Privilege protects not only information exchange between a lawyer and client, but also includes persons authorized to act on their behalf, called agents. Communicating confidential information to a lawyer's legal assistant, for example, is likely still privileged. Remember how I mentioned that intra-office communication? Also, a formal attorney-client relationship is not always required. The protection extends to potential clients who consult a lawyer to potentially hire that lawyer for legal work, even if the lawyer is not ultimately hired. For the privilege to apply, the communication must be made for the purpose of helping a lawyer provide legal services to the client. Communicating with a lawyer for any other purpose, such as asking for public relations advice, for example, may not be privileged. Finally, communication must be confidential, meaning it is not intended to be disclosed to others beyond the lawyer and client. If someone other than the lawyer and the client are present when the communication is made, even family members, friends, etc., the client risks waiving the privilege. Risks. Some people interpret that as automatically waives the privilege. That's not true. Just so we're clear. In criminal cases, we're going to skip this section because we're not talking about criminal cases here. The privilege belongs to the client. Unless an exception applies, a client may refuse to disclose the information in a court proceeding and may prevent the lawyer from doing so. Exceptions include communications relating to the death of a client or disputes between the lawyer and client, among others. Clients should be very hesitant to reveal privileged information, should almost always consult an attorney before doing so. Now, obviously, Vic is Ty's attorney, and they have not asked for any communications between Ty and Vic. Now, it is possible that Ty is the attorney of anybody else as well. He is an attorney acting in this area. So it's possible that Ty is the attorney of somebody else in this lawsuit, or somebody else who's a non-party that they're asking for information from. So communications that are meant to be confidential between Ty and any potential client or any actual client would be privileged, so long as those communications were for the purpose of confidentially discussing legal strategy, right? So let's be clear on that. The work, did I say Vic is Ty's attorney? Oh crap. Ty is Vic's attorney. I'm not even drinking, dang it. The work product doctrine. Now let's get into this one because this is probably more important here. The work product doctrine protects the ideas and strategic decisions made concerning a case by guarding information revealing the thought process of an attorney, a client, or their agent. This can include notes, memoranda, letters, emails, not just communications. Protecting work product helps the litigation process by safeguarding an attorney's work in preparing for trial and requiring an opposing party to prepare its own case. The work product doctrine is found at Texas Rule of Civil Procedure 192.5 in Texas cases and Federal Rule of Civil Procedure 26B3 in federal cases. Let's take a brief look at the rule and then we'll go back to the document. Where is it? 192.5. Here we go. I'll blow this up a little bit. I'm not ISIS. I mean enlarge and enhance. Zoom and enhance. Okay. Here we go. So work product defined. Work product comprises material prepared or mental impressions developed in anticipation of litigation or for trial by or for a party or a party's representatives, including the party's attorneys, consultants, sureties, indemnitors, insurers, employees, or agents, or communication made in anticipation of litigation or for trial between a party and the party's representatives or among a party's representatives, including the party's attorneys, consultants, sureties, indemnitors, insurers, employees, or agents. Protection of work product. Protection of core work product, attorney mental processes. Core work product, the work product of an attorney or an attorney's representative that contains the attorney's or the attorney's representative's mental impressions, opinions, conclusions, or legal theories is not discoverable. Oh, sorry. It is overlapping there. I apologize. Got that fixed? Yeah. Thank you. Is not discoverable. Protection of other work product. Any other work product is discoverable only upon a showing that the party seeking discovery has substantial need of the materials in the preparation of the party's case and that the party is unable, without undue hardship, to obtain the substantial equivalent of the material by other means. The work product doctrine is going to absolutely hinder their production request because they're going after the attorney rather than anybody else. They're going after the attorney for the information, which is generally an issue. Felipe Mouve says, Nick, how this POS can ask for all that stuff? Can Ty do the same? They abuse discovery and now this. Effing a-holes. Wow. Well, you can ask, but this isn't biblical. It's not ask and ye shall receive. Well, ask and you may receive one of these. I'm going to guess. That might be coming. Maybe it'd be a little more formal than that. But I think that's what you may shall receive. That might be biblical. Blackhawks 81H says, Nick, please consider temporarily legally changing your name to West Nile Rekieta or just West Nile so that Lemoine has to keep owning himself every time he files something involving you. Can always change back after. Brian Dewick says, you digging through all these rules and cross-referencing them reminds me of trying to debug someone else's code just by reading it. Painful. Yeah, it's not fun. Not fun. So here we go. All right. So there's some exceptions. Even if made or prepared in anticipation of litigation or for trial, the following is not work product protected. Information discoverable under 192.3 concerning experts, trial witnesses, witness statements, and contentions. Trial exhibits ordered disclosed under Rule 166 or 190.4. The name, address, and telephone number of any potential party or any person with knowledge of relevant facts. Any photograph or electronic image of underlying facts, or a photograph or electronic image of any sort that a party intends to offer into evidence, and any work product created under circumstances with an exception to the attorney-client privilege in Rule 503D of the Rules of Evidence. Okay. For purpose of these rules, an assertion that material or information is work product is an assertion of privilege. White privilege. Okay, let's go back to the easier to read stuff. Work product includes material prepared, mental impressions developed, or communications made in anticipation of litigation or for trial. In anticipation of litigation can be a difficult concept, as it can be difficult to figure out when parties think litigation is a possibility. Let me give you a hint. This is typically not to deal with a person who goes, I'm going to contact an attorney because I think litigation might be possible. At that point, anticipation of litigation has occurred, okay? Typically speaking. This is for companies who have developed various materials that they may want to protect later on. They can't assert a work product privilege on a material they prepared like 5 years ago. That's not reasonably in anticipation of this litigation. So they may have produced it 5 years ago. It was relevant to a thing. They try to call it work product because they have in-house counsel or something like that. But they would have a higher burden to show that was actually made in anticipation of litigation. Where this is not going to apply. Like if someone's actually searching for an attorney, they're in anticipation of litigation at that point. Texas courts use a two-part test to answer this question. First, they ask whether a reasonable person would have anticipated litigation under the circumstances. Second, they ask whether the client trying to keep information confidential believed in good faith that there was a substantial chance that litigation could happen and made the notes, communications, etc. to prepare for that possibility. There is a rarely used exception to the work product doctrine. Materials made when preparing for litigation that do not necessarily reflect an attorney's thoughts, called non-core, may be turned over, but only if the opposing party can show it has a substantial need for the information to prepare its case. The party is unable to obtain that information by other means without undue hardship. Said simply, the information must be very important and difficult, if not impossible, to obtain otherwise. Core work product, which actually reflects an attorney's thoughts, is absolutely protected. So there you go. So asking, here's the thing. I won't go through how they're different. That's not really important. Or the common pitfalls. They're not really relevant here either. Basically, the common pitfalls are the client holds the privilege. If the client gets rid of the privilege, then the privilege is gone. So if the client is out there talking about the protected information, then you're not going to have that privilege. It'll be gone. Or if they can produce documentation that the client specifically waived privilege on the communication in question, then it's not going to be privileged anymore. That's the long and short of it. Work product is broader than the attorney-client privilege. Attorney-client privilege is narrow. Work product is broad. And this is the problem. They're asking the attorney for communications that he had, which would necessarily include notes, thoughts, and preparation for litigation. He's asking for communication between an attorney and witnesses. Blink, 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 blink. And not only is he asking for the communication between an attorney and witnesses, he's asking specifically for communication related to his client or the litigation. That's definitely going to be protected work product. And it's going to be core thoughts. There's almost no way around it. I mean, I'm sure there's going to be some argument that there's a way around it, but good luck. Good luck procuring that in any reasonable amount of time. You're going to have a long fight if Ty chooses to fight it. Now, I don't know. Maybe Ty will just give Lemoine what he asked for. That's probably going to happen. I think Ty's probably in a mood where he would want to give Lemoine this privileged communication that he asked for. I think. No, I don't think. What is I think my video is glitching up here. Just a second. What is up with that? But we're going to see if we can fix it real quick. My computer's like hiccuping in real time. It's great. It's not the internet, or is it? Jeez. I don't even know what is causing this. Pause. Maybe it's this. Very weird. So I don't know what was causing that. It might have been my online backup, but hopefully that'll be fixed. I'm not noticing it anymore. I was seeing that. Okay. Nova Zero says, Nick, can you help me set up a fund to sue you? You've continually and fraudulently, I guess, represented that certain parties are competent. Can we also more of the tax return? Ty, please file no. Okay. So there we go. All right. I think it's about time for a new router. I think that's true. Let me get one of those AX routers or whatever. Well, no, it's Wi-Fi 6 or something. I think they changed it. Oh boy, I just need one with as much like juice as possible to get through everything. Mine is getting old. It's a good router, but it's been through some hard years. So anyway, long story short on that, this is almost definitely under either the attorney-client privilege or the work product doctrine. And they're asking, again, specifically for communications related to the litigation, which is going to contain the attorney's thoughts on the litigation, necessarily. There are other issues at play here, of course. There is a journalistic shield law that would be at play in any information they're requesting between Ty and I, because I have a set of, there are journalistic shield laws in place to protect confidential information given to me by sources and to protect information that would lead to the discovery of who those sources may be. So they have to overcome the journalistic privilege there. They would have to potentially overcome an attorney-client privilege for anyone that Ty might be representing outside of Vic, and they would have to overcome the work doctrine, the work product doctrine, and that privilege as well. So why do this? Lemoine isn't that stupid. He has to know that this is an issue for him. But maybe he is that stupid. I don't know. Hold on one second. Let's see. What do we got here? He's been... Let me get these pulled up for you. I mean, I don't think Lemoine's as stupid as I think he is. So I think he has to know this. So he's got a goal of some sort. Let's see here. Here we go. There. Did I get that pulled up right? Aha! It's cut off. Hold on. There we go. Oh gosh, I gotta do this. Is this in reverse order? Yeah, this is in reverse order. Hold on. No. Okay, so this one doesn't matter. These are... Oh, here Lemoine is criticizing the legal discussion going on Kiwi Farms. So Kiwi Farms has a specific thread where people, a few attorneys and largely lay people, come together and they discuss legal processes, right? So these are lots of people who are learning about the law through some sort of process, mostly their own reading and research, but some of them are getting it from a source like me or a source like Law Twitter, and they're trying to come out and figure out this stuff. There are, of course, there's at least one attorney, if not a couple others, on Kiwi Farms who also help sort through some of these issues. So what Lemoine is doing here is attempting to dunk on a person who has no idea no specific formal training. And he's replying to Greg Doucette because he's got a friend. So someone said, it's an abusive process to force the other side to respond to it, while if a motion for sanctions comes around, he can claim that he never actually did it. He's such a slimy little West Nile riddled, wheezing, half-dead pussy. So what they're referring to here is Lemoine is filing this notice of intent. Now, they're wrong on this because there is a rule requiring this notice. The notice of the intent to file a subpoena. We read the rule. It says that there's 10 days. 10 days notice must be given to file the subpoena. So this is kind of but it's a funny conclusion. And this is, the timing of this is the interesting part because he's really pushing up against this window. But this looks similar to the notice of the intent to request notice that they filed on me, which is a little bit different because that wasn't a notice of an intent to serve a subpoena. It was a notice of an intent to request permission to serve a subpoena. Very little bit weirder on that one. But this is his criticism there. And then he's responding to someone else, sort of. Notice he's in protected mode. So he can't like really carry on a discussion with the outside world. His dunks are largely invaluable. He's literally dunking to like the few people he hasn't determined are incels. And I don't know, but it's possible that Jay Sean is a literal incel. So that's a kind of a funny term for him to use. Like he may be medically celibate. I'm not sure. And like sexual activity, he may need permission from a doctor to engage in that. To find that kind of like a funny sort of potential situation. I hope that's not the case because that would be awful. That'd be awful. There are lengths even I won't go to. The only reason I would find it funny would be his ironic use of incel for other people. But, you know, so he's banned the incel horde and he's also protected his tweets. So like nobody can actually read this outside of the few people who he has deemed worthy to follow him. And specifically, he's talking to himself and T. Greg Doucette. Now this one, there was some argument over whether or not discovery is still stayed by the TCPA at this point. He is suggesting that discovery is no longer stayed because on the filing of a motion under this section, all discovery in the legal action is suspended until the court has ruled on the motion to dismiss. So he's suggesting that discovery is available at this point. So the poll options are can't read or is a dum-dum. So he's calling the Kiwi Farms person a dum-dum here. So good job. Good job. This is playing off of that. Frankly, it's disgusting that he's trying to do this, and that is what he is attempting to do. He wants discovery here. So I think these were in reverse order. I think this one might have predated that one. But so again, responding to the Kiwi Farms thing. Here's the problem. Jay Sean. The hold my beer comes at the end of the meme. That's the hold my beer is the punchline of the meme. The hold my beer doesn't come at the beginning of what you're going to say. Like that actually, that turns it on its head. It doesn't work that way. I know that you don't understand memes and funniness and hilaritizing. Is that the word? I know you don't know that. I know your personality is just cancerous. But hold my beer comes at the end. But let's go back. And notice he is responding to Renfamous here. So also, just a gem of a human being. Hold my beer. There's no way the court should allow that subpoena. It's completely meaningless. And then he quotes, Lemonhead doesn't get to effing engage in discovery for the purpose of sanctions. There's just no way. This is in no way the intention or reasonable interpretation of 27.006B and then he says incorrect. Oh, no. And frankly, it's disgusting. So this one comes before this one. All right. Now I'm getting it. Messy. Twitter's format for reading chronologically is so ugly with their approximations of time. But okay, so here's the beginning of the quote and there's the end of the quote. But he still starts it with hold my beer because he's a weirdo. And then finally, he's got... So then he goes to the motion to dismiss portion. Okay. So he's not good at Twitter. I've got that much figured out. He doesn't understand hold my beer. So maybe he's not as smart. But Lemoine has to know. He has to know that he's not getting this stuff, right? Like that is obvious. You can't ask for this stuff. It's almost entirely going to be connected to work product. And more importantly, there are other places where you could attempt to get the information, right? There are other instances where you could attempt to get the information, other people you would have to subpoena. And you have to exhaust those options first. But I think he's got a plan. Actually, of course he has a plan. He may be weird, but he's not stupid. All right, we're not going to go through this one. This one says the same stuff, I believe. It's the same stuff, but this is to the law firm itself. So again, yeah, good luck. Good luck getting that. But let me tell you what I think he's trying to do here. So he's going to file this notice. Ty's probably going to quash the notice or quash the subpoena, whichever one he wants to do. He'll quash it, right? And then Lemoine will use that to try and force a hearing on the issue where there otherwise wouldn't be a hearing necessary. And he's probably going to use that move to try and push out the window on this and then get the court to weasel his way into discovery that he wanted to avoid the entire time. They wanted to avoid the discovery as much as possible. Now he's trying to get discovery. The judge didn't give him enough time that he wanted for. So he files this, then Ty can quash it. Then he can go ahead and at that point he can move to he can move, or he can request a hearing on the disputed notice or the disputed subpoena. That's my thought on the issue. And is that a good play? It's a little risky because he's asking Chup to do something that, and I use this knowing full well what I'm saying, okay? Logically, Chup should be adamantly opposed to. He's asking Chup to order Ty to turn over documents that would violate attorney-client privilege and the work product doctrine flat out. That's a problem. But Chup is Chup. Chup handed them a win. Maybe he's thinking that because of that win, he'll have smooth sailing into this this very, very reliable scheme or whatever. Maybe that's what he's going for. I don't know. Seems risky. Seems risky to piss off a judge when you're ahead. All of this seems risky. You're ahead. File your proposed order with your affidavits, with the dollar amounts, and Chup's probably going to award it because he pretty much knows it's going to appeal anyway. So just file it. But that's not their goal. And this is, of course, an argument that could be made if this were to go to a hearing. They're doing this in bad faith. They're trying to draw out things. They're trying to expand costs. They're trying to prolong this. They're trying to continue defaming the person that they've suggested that they're not trying to defame. They're trying to continue to publicly humiliate him the entire time. That's what they're, you know, that's obviously part of what they're trying to do here. Make no mistake. Make no mistake. And if you've read any other of Jay Sean's very, very weird masturbatory tweets, I can find. See, I think I've got another one in here that's really weird. Let's see. Here we go. Okay, here we go. The amount of unbilled time I spent thinking, researching, plotting, precisely because of what was being done to my clients and co-defendants. Agreed. I teach my associates this. I truly have to hate opposing counsel to give them motivation. When I do, it's because I want them to give me their A game. Because when I win, I'm going to make it known that they lost. No one read your blog, you weirdo. Agreed, I just can't do it. It would consume me, which is why my troll defense is at max protect. This is a weird masturbatory tag tweet. That one's odd. This one, I get it. Some lawyers get in the zone by hating their opposing counsel. I guess that's how some people do it. But yeah, it'd be a shame. It'd be a shame if it was, you know, introduced to bring up the fact that maybe he's doing this for improper reasons or something like that. But, you know, what do I know? Who knows? Anyway, the guy's weird, man. He is weird. And it's written all over his face, which is definitely an animation. It's not a static image. So here are the recap. Here are the documents. The documents are asking for things that are likely protected by privilege, if not several privileges. He's asking directly to a party that probably will not produce them. If I had to guess, because if I were the attorney, and if you talk to pretty much any attorney, and attorney says, you say to the attorney, okay, riddle for you. Opposing counsel wants you to turn over all of your communications with witnesses to the case, and some press people that you talk to. What do you do? WYD, fam. What you do? The attorney's going to say, yeah, I'm not going to do that. Yeah, I'm not going to do that. I'm not going to give them my notes, my impressions, my communications. I'm not going to give them... Oh, and by the way, all of the communications that they're requesting are just specifically the ones related to the case you're litigating with them right now. So they just want your candid thoughts and words on the case that you're litigating right now. Are you going to do that? No. 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 No, I'm not going to do that. So that's the summary of these documents. They're ill-conceived. But I think ultimately what they're trying to do is they're trying to force a hearing that they know they don't have grounds to call in the first place. They have a legal theory which may allow them a hearing on attorneys' fees and sanctions. Maybe. It may allow them. Like I said, I've heard of it happening before. I don't have a citation on that, but it is something that may have happened, you know, in the past and related to the TCPA. That said, the frequency that it happens is not held up in any review of the appellate court that I've done. But I'm I'm not claiming to be an expert on how Texas does this stuff. In fact, there are several people in this that I'm pretty sure are not experts. I don't actually think Lemoine is much of an expert on the process of the anti-SLAPP. I think he might be an expert on the applicable law. I think he's an expert on the case law out there. But I think that he's not an expert on the process. I think that Judge Chupp isn't an expert on the process. I actually would be interested to find anyone who's an expert on the process, because I don't think that the TCPA has enough of a consistent set of case law to establish its process in this way. The fact that the one guy who supposedly is the expert, who writes the blog, didn't you read my blog, fam? The one guy who writes the blog specifically said that he's not aware of any cases which would specifically allow for a hearing on this issue. But he thinks that this case is the best because it says how we interpret the sanctions according to these rules, and these cases which allowed hearings that aren't under the TCPA but do analyze it in the same way, they allowed hearings. So that's the leaps of legal reasoning, and that's not a bad argument. I'm not belittling or criticizing that argument. I'm saying that is not authoritative, that it definitely has a hearing. So they're asking the judge to apply this thing. Now, I think he might be banking on Judge Chupp not actually having any idea how a TCPA is run. I think that much is apparent. Oh, and by the way, I'm not sure that Judge Chupp has ever actually had a TCPA go to trial. I've been looking through the Second Circuit Court of Appeals. Second Circuit Court of Appeals. And Judge Chupp does not have a single TCPA that's been appealed that I can find. So that's weird because of each party's propensity to appeal a TCPA, right? It's a pretrial motion. It's going to be made. TCPA motion is going to be made in any case where the TCPA might apply because it's devastating to make it. So if you're going to go to trial, like you don't settle right away, you've got your 60 days to file that TCPA. It's going to be filed. The result is so devastating to either side that it's likely going to be appealed in some way or another. Either via interlocutory appeal if the defense loses on some of the issues, and the TCPA is so strong that the defense is heavily motivated to appeal an unfavorable TCPA ruling. Heavily motivated because it's likely going to get overturned. There's a good chance of it because the TCPA is so broad. And because the TCPA is also supposed to protect plaintiffs, to allow them to bring a prima facie case to establish that they actually are bringing a meritorious lawsuit, it's likely that any plaintiff also facing sanctions and attorney's fees is going to appeal simply because the appeal is a low-cost possibility of removing those sanctions and attorney's fees and proceeding on with your case, which you tend to believe has merit if you bring it. So the likelihood of appeal of a TCPA is high, right? The likelihood of filing a TCPA is high. Judge Chupp doesn't have any that I can find. Now, maybe I'm not researching appropriately, and if anybody out there can find Judge Chupp on an actual TCPA, because I found his name on documents with TCPA included in the documents, but I've not found an appeal, even pending, of a ruling on a TCPA by Judge Chupp. So if anybody out there can find one, I would love to see it. That'd be very interesting. I'm not sure that it exists, which, if it doesn't exist, there's a weird possibility that Chupp has never taken a TCPA motion, or if he has taken a TCPA motion, they were all resolved by either mediation or settlement prior to any sort of resolution coming out, or that would foreclose the chance of appeal. That seems crazy. So there you go. But I'll call that out. If anybody happens to see that, please direct me to it in your research. I know a lot of people are looking for this. I don't know if anybody's been able to find it at this point in time. So very interested to see what's up. Okay. So with that said, I mean, that's where we're at on this stuff. Oh wait, Devil Hunter Nero says, who does Lemoine think he is? Bill Belichick of the Patriots during Spygate, trying to get Ty's playbook. No, again, I think he's going to argue. He's going to try and argue that that he's going to make the arguments that Ty's appearance on this show or his communication with me somehow obviates the work product doctrine. That, of course, is nonsensical, because Ty has every right to come onto any sort of media platform, as does Lemoine. To go onto any media platform and make statements about the case. And those statements are obviously not going to be protected work product because they're statements made in public. They're not going to be protected attorney-client privilege because they're statements made in public. However, those statements are available through any number of other means, including just merely grabbing them from the video. So that's not going to get the discovery they asked for. Any other statements that they make, or that any other statements or documents that they're asking for, are available from the other parties, right? They could subpoena Chris Slatosh, Chuck Huber, Stan Dolan, or me. They could subpoena us to try and get the information. They haven't demonstrated any undue hardship in accomplishing that task, or even that they've attempted to accomplish that task. So that's going to be a problem too. What I think Lemoine is trying to do, ultimately, is a couple things. One, like I said, he wants to bait that hearing. He wants to bait that hearing out of Judge Chupp, a hearing that otherwise is unnecessary, but he wants that hearing to occur. Two, he wants, likely, to try and take the statutory sanctions, which sanctions in relation to a TCPA are imposed to punish the bringing of a frivolous lawsuit, and to actually, not really. The sanctions are solely intended to discourage the filing of a subsequent lawsuit that is similarly frivolous to this one. That's what the sanctions are for. What Lemoine is trying to do is trying to blend that sanction award with an idea that some bad faith act took place that he now gets to get additional sanctions out of. He hasn't shown that in any way, but he's trying to get there without showing it by forcing a hearing to then ask these questions at a hearing. He knows he's up against a time crunch and he needs more time, so he tries to do this to push back the window, because he knows, like, if he tries to subpoena me or Slatosh or Chuck Huber or Stan Dolan, he's probably going to be met with a motion to quash, and then that will delay his efforts to do that. So that's going to be a problem for him. He's going to have a fight on it, and he doesn't have time for a fight unless he can convince the judge to expand the window that he's got. So he's trying to do these things. I also think he is trying to run up the bill a little further, which might have to do with him not actually entering the bill into the record. He's going to serve the existing bill, and with that service, he will likely include a statement that says something along the lines of, the final bill will be produced at the evidentiary hearing, which will reflect any additional work done in preparation for the evidentiary hearing. And he will try to get that done. So they're going to try and increase costs and then go ahead and impose those costs on Vic. If I had to guess, these are all motivations of Jay Sean Lemoine. Probably thinks he's very, very clever in doing this. It's not clever. It is risky because you have the favor of the judge. You're risking the ire of the judge by asking the judge to go after an attorney and to force an attorney to produce documents that are very likely protected. When you have the favor of the judge, just use it and just ask for what you want. Let's see. Felipe Mouve says, Nick W. Nile does it for one to add to his bill. Is that possible after Chupp's decision? It's arguable. It's arguably possible. It's not, you know, it's all argument. You would certainly argue that any discovery related to sanctions is not a discovery request related to the TCPA and is not a reasonable attorney fee under the meaning of the TCPA. You would argue that. Which argument wins is up to a judge, right? So Ty gets busy so he doesn't appeal on time. I think that might be part of it, trying to attack situational awareness or something like that, but I think that's low on the list. I think they are probably pretty confident that an appeal is going to come in a timely manner. But, you know, who knows? I don't know. Maybe they think Ty'll screw it up. JCF Data says TRCP 205.3 says non-party by serving reasonable time before the response is due, but no later than 30 days before the end of any applicable discovery period. What discovery period is applicable right now? That's an argument, right? Welcome to law. Welcome to law. What even is an discovery period following the disposition of the case? We know that he's issued a ruling. Jay Sean has ordered that ruling lifts the discovery stay, but are we in post-judgment discovery at this point? Have we moved to post-judgment without a sanctions and attorney's fees ruling? Do we have a final ruling on the case that would then allow post-judgment recovery? Because a judgment hasn't been entered as far as a monetary judgment. So are we in post-judgment discovery? Are we in some sort of interim discovery period? Is the discovery period active as long as the court has jurisdiction? Does it end on November 4th when the judge has ordered them to issue or to file their documents? All of these are arguments that the parties would have to make. All of these are discussion points. They'll have to find out. They'll have to research and make the arguments to the judge. I don't know. I don't know the answer. No one actually knows the answer. People might have a really good idea of the answer. If they're an expert, if they do this all the time, they may have a really good idea of the answer on this question, but it will be an argument if the attorneys choose to make it an argument. JCF Data says, and 205.3, a party requiring production of documents by a non-party must reimburse the non-party's reasonable cost of production. So if the judge even allowed this, then Real and Toye have to pay Ty and Beard, Harris, Bullock, and Hughes cost. I suppose. It might be really expensive to compile a bunch of electronic discovery, so, you know, there you go. Maybe they think Ty'll do it just to get the money for the discovery or something weird. Yeah. What their ultimate motivation is, I've listed a bunch of my theories. Only the deranged mind of the mosquito, right? Like the bat, the mosquito. Only the deranged mind of the mosquito can go ahead and actually tell us, but he's not going to, right? He won't tell us his motivation. Because one, no one would see it on his protected Twitter account. Two, he's not going to reveal it because might even be improper, and it would look really bad if that happened to come out. So, but you know, there you go. That's where we're at on these things. I have a feeling a big, like, maybe just the production is met with a photocopy of a middle finger, or something that says, you can find, please find, please find requested data in Appendix Ligma. Ligma balls. Could you imagine like sending someone that? Like this big binder. It just says, please find the requested discovery production in Appendix Ligma. And then it's just a bunch of pictures of scrotums or whatever. Good job. Ah! Oh boy. All right, guys. Well, I'm going to have to get to these super chats and justice chats that have come in. I believe I'm going to do some Twitch tonight. I'm not entirely sure what game I'm going to play on Twitch tonight, but I like the Twitch thottery. It helps me wind down after one of these streams. I am extremely tired, and I'll talk about why on Twitch. So I don't know. I might do an hour to 2 hours. I don't know. I don't have an early morning tomorrow. Thank God. Oh, hate early mornings. I don't have an early morning tomorrow, so I might stay up a little bit. But yeah, so come join me on Twitch. Make sure you follow on Twitch. Looking to get that thing bulked up. I am off of Twitter, but there are other social media contacts in the description. If you do want to follow me on Instagram, it's on there. I might start posting to Instagram more. It's such a weird format. It's also, I think my Facebook business page is on there. I don't know. I hate using Facebook in general, so I don't know. Maybe that's why I don't understand Instagram. I'm really digging the YouTube community tab. I'm hoping that is actually getting notifications to you guys in a better distribution method than these other weird ancillary things. But you are welcome to follow me on any of these places. Of course, if you join Patreon or New Project 2, you can get into the Discord, and in the Discord, you can get all sorts of updates and all of that stuff that is going on in there. I did have to change it so that it charges you up front for Discord membership or New Project 2, or no, Patreon. I had to do that because the cuckoldry from a little annoying whiner on the internet who was joining the Patreon and then quitting the Patreon to avoid paying and then joining back up later, but still holding access to the Discord. So he was never actually paying. So I had to remove that guy only because he didn't pay, which is rude. It's just a pay server. So if you want in it, just pay for it. Simple. But yeah, you can follow me. You can also follow me on Twitch. I'm exploring ways to expand the Twitch channel to something. It's not this, right? The legal stuff will remain here, other than the chill out Twitch streams where I just, I'll answer questions or whatever. But the bulk of the legal stuff is here. There will not be like Twitch exclusive legal content or anything like that. But I'm looking to bulk out the Twitch channel, which will be something completely different, not related to law, just fun, video gaming, watching shows together or whatever. Maybe watch My Cousin Vinny or something over there. That'd be fun. But stuff like that. So if you're interested in that, come follow me on Twitch. Right now, what I'm gonna do is I'm gonna read through these chats and we're gonna close out this stream. So if you are someone who leaves for the chats, thank you for watching tonight. Thank you for hanging out. We'll see you next time. Should be tomorrow. Tomorrow, announcement to those of you who missed it. I got a new whiskey called America Whiskey, and tomorrow there will be a whiskey review stream in which I will review the whiskey early on in the stream, and then I will proceed to drink enough of the whiskey to become intoxicated, and then we'll scream and yell and laugh at some sort of subject. I don't know what subject yet, but we're going to drunk cast through something. Maybe I'll have a guest, maybe not. I don't know. I don't know what I'm going to do yet. I'm going to save that for tomorrow because tomorrow's main theme is the whiskey. It's a Patreon promise that I have failed to deliver, and I am going to rectify that tomorrow. So come watch me drink a Merca whiskey. So yes, Twitch stream is tonight after this. So a Whiskey Ace Attorney is dangerous. Whiskey Ace Attorney is dangerous. So, but we'll see. I can't get Drexel for tomorrow. That would be great, but there's no way I can get him. I could maybe get Q live in studio. Otherwise, I may be able to get a remote guest in. Someone I haven't talked to in a while might be great. I don't know. I don't know who's available. I don't know what I'm going to do. Maybe someone I never talked to before. We'll get liquored up. All right. Let's do these chats. Start with the justice chats because they're right here. Baron von Stargert says, completely off topic, but how did you finance law school? An educated failure myself, I was wondering if you know of any resources that somebody with no money to speak of might finance a legal education to pick myself up after 26 years of poor choices. Well, I scored really well on the LSAT. I scored well enough to get a scholarship to pay for a chunk of my legal education. I have student loans like other people, and I also received help from friends and family. So a great combination of scholarship, student loans, good old-fashioned help, and also I was in banking and finance for six years prior to going to law school. I did not go to law school straight out of undergraduate. So I also had various savings and investments that helped pay for law school as well. Or those are more geared towards paying for things like, books, food, a mortgage, all of those things. But yeah, it was tough. It was very tough. I don't envy anyone going into it. But scholarships, do well on your LSAT. If you don't do well on your LSAT, take it again and do better on your LSAT. If I would have done better on my LSAT by taking it a second time, I probably could have gotten a bigger scholarship. But I didn't. But you can. Take your LSAT, do it well. If you don't do it well, do it better. And take it again and do it better. And then the other thing I can recommend is, of course, I went to a small school that wanted enrollment, especially at the time. I went to school at a good time when enrollment was declining, so that helped. One thing to do. This is advice that was given to me by a trusted friend, and I'll relay this advice to you. If you want to go to law school and you taken your LSAT, you've got your score, got your GPA, you got everything hammered out and ready to go, contact the admissions department prior to applying or right after you apply. One of those two. Contact the admissions department and set up an in-person interview with the admissions staff. There's admissions staff at a law school is likely a very small group of people, 3, 4, less than 10 for most of these law schools, especially if you're going to a smaller school, less than 10 people. And you can go and talk to them, and they will learn your name, and they will hear your story, and you get to tell them like why you're interested in law, why you're here now, what you're bringing to the table, why you're different than every other person whose name they're not going to remember because they just saw them on, the application pop up. Who's this? I don't know. Well, then they pop up and they're going to be like, oh, hey, that's Joe, whatever. I talked to that guy. He was really nice, articulate, well-spoken. He talked about his journey through this profession or this career. That might be a very interesting person to bring into school. He's got a really good LSAT score. All of that stuff. That will help you tremendously. Do it. Do it. And the final thing, when you make your application to law school and you have a personal statement, just like other grad school. Why are you going to be in this school? Okay? Write it and then have someone else edit it and proofread it and make it someone who will be honest and mean with you and tell you this is boring, I don't care, this doesn't make you look good, you're a moron. Have them get a cruel editor, get someone who's critical of you, get a trusted professor, no nonsense type of person to go through that statement and help you refine it and make it better. All of these things matter. If you want to get into a law school, if you want to get a scholarship, if you want to do those things, make the personal connections. It's just like everything else in this world. Networking matters more than any of us want it to. Networking matters. So there you go. All right. Sorry, that was a really overwrought answer, but I wanted to give you the best answer I could. Because if you're gonna undertake the financial and time investment, get it mitigated as any way you can. Beige Devil says, what's to stop Beard & Co. from generating 984 gigabytes of text messages between themselves of the words Lemoine loves being raped by a mosquito to turn over to Lemoine and his cuck associates? I don't know if that's related to litigation, but maybe. Hellsnake says Dead Sea Scrolls. I mean, what's to stop them is that would probably get them sanctioned specifically. Dead Sea Scrolls tattoos, all cardboard boxes, all carrier pigeon, all messages from Donald Trump, and finally, anything that may have to do with case at hand so we can dox and harass anyone that we can defame. I think you missed that in the document. Oh, well, there is that too. Wadsworth. Oh, I missed this one. He says, can Ty just respond with a selfie of himself wiping his booty hole with this request? I mean, he could. Again, not recommended. Might be a violation of the rules of decorum. A professional response of no thank you might be better. Crusader Saracen says, so short answer from Ty, no. Long answer, no. But can Judge Chup bungle this? Yes. Disregard the rules and force Ty to disclose all requested material anyways. He can. That would probably end up with a petition for a writ of mandamus, because that would be outside of, I mean, that would be a broad violation. It would also delay everything. So maybe that's what they want. That'd be great. Architect of Fate says, tune Battle Hymn Republic. I'm not going to sing this. Mine eyes have seen the simpness and the shuffles of the cuck. Through the wheezing and his struggles, he keeps the snack tray up. Caged from a chair, he watches Drexel fill his whore. Cleaning up the remains, Lemoine whispers more. Oh, God. That was revolting. Ben Cheever says, Cody's girl is a hoe, a straight-up prostitute. Cody wasn't the first and not the last. I think the mom might have been aware a dumb booty. Sex pause femmes SJW. And when she found out who he was, she raised hell. Sounded that way from the victim impact statement. She said weird things. She did say very weird things in that. That was a strange statement. And again, I wouldn't encourage anybody to make that statement, because to me, it makes you look like you're putting a lot of blame. Well, whatever. Beige Devil says, one thing that I would criticize Beard & Company is that Ty has treated Lemonfuhrer like they are in an honorable duel when he should be going scorched earth on opposing counsel and the defendants. I hope after this, Ty uses their faces for a toilet. Oh, gross. Reminds me of a line from The Bone Collector. You know what it's like for a cop in prison? I became a human toilet. That was a good line. Crusader Saracen says, Lemoine, finally with these dastardly discovery requests. Wait, what's that? Looks up to the rafters. Ty Beard, your worst nightmare, butthorn. McBurn! Yeah! Oh, beautiful. You beautiful person. You beautiful person. Oh, quoting the Gary Busey. Quoting the Gary Busey at me. Oh, God. Okay. Mr. Security says, you're late and gay. One of the few times I get to watch live. Got sent home from work early. Take my 5 shillings, you beautiful cuck. Hey, thanks. Jay says, early and hetero. I want my money back. I wasn't early. Hetero's in the air. Hetero's in the air. Mr. Leon says, here's some cash for finger guns and Hank Hill. Yeah, that's a great topic. We can talk about finger guns tomorrow as well, because a 13-year-old girl has been charged with, I believe, a felony for dangerous finger gunning. So there you go. Austin Heartless says, hey, Nick, I sent an email. I saw it, buddy. Subject line is musical instruments for less fortunate kids. Let's talk about that one tomorrow. That's about a GoFundMe for less fortunate kids. I'll look it over. Who are more fortunate kids? Freighter J says lemon, and then, well, there's a lemon, and then there's a mad face. Cowboy FMJ91 says, that one thought already laid out the groundwork for Habercorn with that tweet involving Vic and Todd ain't playing their games. Yeah, let's hope Todd doesn't have to deal with this too. But I think, you know, if they think that Vic is done and dead, I imagine they'll be coming. The Purple Rant says Chris Hansen is getting involved with Onision. They're trying to find a way for 2 of Onision's victims to raise money to press criminal charges. Why do they need to raise money to press criminal charges? That's weird. 2012 Jameson says James's mom is a physician, a pediatrician in Texas. Oh. That one's going to burn me up tomorrow when we talk about it. Adzuma99 says, every time we see Nick stream, his beard game evolves a little bit more. I'm probably going to trim it down, though. I got to trim it a little bit. It's too far down the neck. Pretty soon I'm going to end up working at a software etc. or in a GameStop. That's what they're called now. Mr. DJ Fly High says, you should get Coleon Noir and Brandon Tatum for your Second Amendment chat. Easier said than done on some of these guys. Michael LaValle says, if Proud Boys claimed it was staged and no one was injured, then there would be no crime to prosecute. Antifa guys would have to come forward to deny, and then they could have been charged as well. That's a nice theory. That would work in civil court. That is not going to work in criminal court. The state has the right to prosecute whether or not a victim is there. You know, who knows what their defense attorneys could have done differently. All right. Kevin McLeod says, sounds like the statement from the mother was crap. Last Sigil says, devilish domain vortex and gloom of wicked ziggurat. I don't know what that means. Did I just activate a sleeper agent? Ah, dang it! I promised myself I would never accidentally activate a sleeper agent. I think I might have. Random Blaze says, when will Ty be filing the Rule 215 violation against Lemoine, Nick, seeing as he is going in dry and without the sacred ointment? Do I have the Texas rules somewhere still? Let's find Rule 215. I'm not familiar specifically. Rule 215. Abuse of discovery sanctions. Oh, so... Okay, so on this, so this is the abuse of discovery. Okay. Abuse of discovery because they failed to they failed to comply with discovery prior to the TCPA. The problem with this is the TCPA stayed discovery. They didn't file a motion for this prior to the TCPA, so they really have to resolve the TCPA going into this. They can maybe make arguments at the sanctions and attorney's fees hearing to reduce the sanction and attorney's fees due to the bad faith of the other parties. I don't know if they're going to try that. I don't know how effective that would be, but they may want to try something like that. But as far as filing a motion for sanctions due to the discovery abuse, they're going to have to get past the TCPA and then deal with that. They might be able to raise it on appeals. Ty did mention that in one of the hearings that they had done the discovery or engaged in discovery abuse, but that he wasn't pursuing it at that time, something like that. I think they do have, I don't know if they filed their motion to compel. They did file their motion, or they filed a motion to compel discovery, I believe, but they didn't set a hearing on it. They could maybe bring that up on the appeal. That might have preserved the issue. It's hard to say. I don't know what they're going to argue. You have a limited amount of words and pages, so they have to hit the highest impact arguments that they can. Okay. Let's see. It's a Cakewalk says, thoughts on the Massachusetts bill trying to ban the word BITCH. I think they're a bunch of BITCHs, personally. That's amazing. That's amazing. We're banning words. There are states trying to ban words. Why? It's 2019. Are we so far away from that whole free speech thing? Some nobody says pummeling makes it sound one-sided, misleading. Maybe. Saw the video. They looked like they had a commanding lead. It doesn't negate anything. Sod off, you silly git. Oh, sod off, you silly git. Says, I just saw Texas crack, also known as Julio's chips, at a Walmart in Minnesota. Ooh. Wonder if they're at my Walmart. Some nobody says, lesson learned, preserve your data in oil painting. Ricky1186 says, Nick, how are you relevant to sanctions? I don't think you are. Sounds like non-relevant, overreach, and privileged information. I'm not relevant to sanctions. They think that somehow I'm secretly representing Vic, despite me openly stating, oh, I've never held myself out as representing Vic. He is not my client. I am not his attorney. I know nothing about the legal strategy of this case other than what Ty has said on this show. All of the other legal strategy, you know, that's between Vic and his legal team, man. So there you go. I don't know how else to say it. They'd have a hard time showing me to somehow be representing Vic while actively not representing Vic, not showing up in any representative capacity in any courthouse, showing up to one court hearing as an observer, not being invited to any of the court hearings. If I was counsel of record of any kind, I would be served in all of this stuff. I haven't been served anything. I've not filed a single document. Obviously, I'm not Vic's attorney. So, how am I relevant to sanctions? I don't know. Just a guy. Just a guy. Finfrog says, Lemoine, I'm coming for you, Nicky Bobby. Oh, good. Gross. Robert H says, damn it, Bobby. Chris Nunez says, hail Nick, no more GoFundMe link in the description. Oh, that is just a sad product of me copying. I'll update that. I'll update that. That was unintentional. What I do is I copy the previous live stream and it transfers over the description and stuff like that, and then I edit it. And I forgot 2 live streams ago I didn't have a Vic stream, and so I took out the GoFundMe link. I'll put it back in on this one and then yesterday's. Thanks for catching that. Some nobody says you caught him/her West Nile fried his/her ovaries. Some nobody says hold my oxygen concentrator. Ricky1186 rather than hold my beer. That's good. Ricky1186 says beer, but we know he drank the Kool-Aid instead. Alex Britton says, hey Nick, it's been a little while since I sent a super chat. Did Jadolf choose the word unbilled because he isn't getting paid? I bet a lot of that unbilled time is spent scoping out those consulates. Gross. No, he's just saying that there's time that he spends thinking about the case that he's not billing. Every attorney does this necessarily. If you billed every single minute that you spend of every single case, you'd be lying. Or like you wouldn't be lying. You'd be brutally honest. You'd be brutally honest to the point where you wouldn't have clients. Because like, let's say you're at dinner and you think, oh, well, this could be this could be that. Now you've worked on the case or something. Are you going to bill for your 10 minutes of time at dinner thinking about it? Probably not. Unless you're an insurance attorney, then you do. Because those guys are horrible. I'm kidding. Ben Cheever says, why would Ty comply with discovery? They didn't. Chemtrail Mix says, what if Lemoine is somehow related to the judge and believes he has a win in the bag regardless? What can Ty and company do if that theory proves to be true? If there were an undisclosed relationship between Judge Chupp and Lemoine, that would be, I mean, Judge Chupp would be disbarred. That would be, he would have had to recuse himself. That is not a thing. That's not a thing. Also, first super chat ever. Love you lots. Hey, thanks. That is, yeah. There would not be an existing familial relationship between Judge Chupp and Jay Sean. So that's that. Karma Tika says Killing Floor or Devil Dagger stream. Maybe. I Asia Frazier says, are you planning a Halloween stream? I would love to. I have to figure something out for Halloween. Last time I did a Halloween stream, I did Allison Mack's case. I accidentally showed her naked on stream and had to edit that out. The joys of live TV and Google search. Thanks Google. And then I talked about the only legally recognized haunted house according to a court. So those are fun holiday themed streams. Maybe we'll do like a murder stream or some grisly, brutal killing stream or something. See, Karma Taika says, will Drexel wear whiteface on the 100K live stream? No, I don't think Drexel will be wearing whiteface. James Keane says, having a gin with a slice of lemon to celebrate. Blaine 20 says, hey, lemony snickets. We'll happily give you as much discovery as your clients gave us. Tucker says, is there a reason the Fuhrer is so fond of letters and not actual motions and filings? I've heard that's just how some attorneys practice. You know, I don't know. I prefer to put things into motions. The only thing is I put into letters in my filings are typically requests for continuances. And those are typically consensual between the two parties. Hey, plaintiff and defendant agree that we need a continuance in this because of this vacation or whatever. That's what I send by letter. The rest of it, I just go ahead and put in a motion. But John Albert says, Nick, did you hear that T. Greg, is a rape apologist going back to 2017? Ooh. No, I didn't. Who is Greg Rapey Face McGreg? Who is he rape apologizing for? I'm curious. Tim Wen says, hey Nick, off topic. Do you need a legal background to do content SEO writing or copywriting work for law firms? You don't need one. It might be helpful to help you understand what would work best as copy for those firms, or what would work best as SEO. Would this be a decent niche to write for? Could I DM you for advice later? You can DM me for advice, but as someone who clearly has never hired a legal copywriter or a copywriter or SEO for legal purposes person, I might not be the best person to ask. You could certainly DM me for advice. Would it be a decent niche? Yeah. Lawyers are likely behind the times largely on SEO. They're bad at technology. They're bad at adapting to changing technology. So and they have money a lot of times. So a decent niche, sure. As long as the economy is up, that's a good expense for lawyers. Says, give us your opinion about Texas jury siding with mom who is changing her 7-year-old from boy to girl. I think it's atrocious, even though I know nothing about it. I'm going to hopefully talk about that a little bit more tomorrow during the drunk stream. My true feelings can come out. Cocky Onsai says, Masterson recorded, audio dumped, farm tools mad. Wait. Masterson recorded, audio dumped. Where? Sakaki, what are you talking about? What are we talking about, Sakaki Onsai? Hit me up. Otherwise, I'm going to start the outro here. Here's the outro. Sakaki, if you can tag me and tell me what you're talking about. I'm sure it's related to the Asterios thing, but I don't know. Where did Dick record and dump the audio? What's going on? What's going on here, buddy? You're leaving me in suspense. You're killing me. I only have this song left to get your message. Check the Discord. Okay. Here. Oh no! Waterboy! Waterboy's gone after Dick. Okay. That's interesting. I'll have to read it. I haven't heard it. Waterboy is done with Dick Masterson. This could be interesting drama. Dick is done. Wilhelm Goldberg says, my grandfather died today. Rest in peace. Hey, rest in peace to your grandfather, man. That's awful. Steven says, isn't the purpose of the TCPA to stop expensive things like discovery? Seems like blatant bad faith abuse. It does. It does. Oh. All right, guys. Thanks for hanging out tonight. Oh, it's a joke audio clip? It's a joke audio clip. Should we play it? Oh. Well, I'm not gonna play it. I'm not gonna play it. Ah, okay. Well, we got a minute 15 to fill here. Maybe we'll make this the outro. Here we go. Hold on, I gotta put on my headphones. Hopefully it's just him saying the N-word a whole bunch so my channel gets banned. The audio clip isn't YouTube friendly? How unfriendly is it? Hold on just a second. Let me see. You guys bear with me. We're gonna figure this out. I'll be the judge of what goes on YouTube. How long is this? Minute 45. Here we go. Okay, I'm gonna play this. I'm gonna play this whole thing. You can't stop me. You can't stop me. Here we go. Here we go. Let me get the volume for you guys. Here we go. I'm going to be quiet during this.
Burger. Oh, dude, feel the cum. Listen, looking at his ass, telling me that now he's gonna start dying. This is the knife. I don't know why. I mean, I can explain why, but I don't know why. I don't know, man. It's incredible.
$1,500 knife.
Yeah.
Holy shit.
Yeah. No, I was talking. There's a little here. Here, give it to me. Yes, just give it to me.
Lay down on your couch.
Yeah. I've been hearing a lot about genital meditation. Come the sperm.
Elvis was into it. Yeah.
That's called being some kind of a boot.
Yeah, but but now that you've seen if you the ang, but you're like that's or but penis. It freak they don't I do well you called a or you wouldn't be interesting.
You know what? I feel like I'm going to come. People lose. I know I have to go in reverse and find a place to dive. Oh,
you're clearly going to have a hard time with this. I know that there's a space right over that I have left you enough space to pull right over that I have left you enough space to get over. There's a space right over that I have left you enough space to pull up and get over. I know I do. You're not going to do that.
I feel like I'm going to come all day. I won't have any problems at all. I just lose. Garbage. What do you think?
Okay, so wait a minute. No, stop. I don't know what else has got going. Okay, that was that. Wilhelm has requested a single shot for Granddad. Yeah, buddy. What do we got? What's good? Let's get. This is Cosquay Finnish gin. It's an aged gin, hence the coloring, right? Gin is usually clear. It's an aged gin from Finland, sent to me by Keck. I'm fond of this gin. I don't know if I can buy it in the States. I don't think I can. So this is to your grandfather. I wasn't going to drink tonight, man, but I am bad at pouring shots. I got a little bit left. Hey, Gator Man, must be nice retweeting Waterboy. Wish I could retweet. If you've never done a shot of gin, highly recommend it. Great. That's great. All right, guys. Thanks for hanging out tonight. You've already heard the intro or the outro, and then you got a second outro. Yeah, I'll have to keep that around for when Dick is on the show again. But hope you all have a great night. Come join me on Twitch if you want. I'll talk to you over there. Peace. Peace.